All right, let's go ahead and call the Senate to order. Sergeant Arms will please secure the chamber doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right, Senators, we are very pleased. Unfortunately, our pastor was unable to make it, had a family emergency, but our esteemed senator from the 37th District has his invocation and will be presenting it this evening. Let's please rise for that invocation.
Thank you, Mr. President. Colleagues, I apologize. Our pastor, Father Nash, had to attend to an emergency in Delaware, so it's a great honor for me. I do have his prepared prayer, so this is not a Johnny Mout's prayer. I can't take credit for that. So as we all come together, good and loving God, as with all things, we begin by offering you our praise and thanks for the blessings you have bestowed on us. We thank you for this opportunity, for this gathering, a gathering that is a testament to the country in which we live and the freedoms it affords, the freedoms it offers to each of us. Bless these men and women with your wisdom as they make decisions for the betterment of our state and its citizens. May these deliberations bear fruit for the good of all, especially the poor and vulnerable. We make our prayer in your most holy name. Amen.
Well said, sir. Thank you. Excellent. We like it. Recognizing the minority whip, Senator from District 6.
Thank you, Mr. President. That wonderful prayer was just amazing, and we want to journalize that prayer. Thank you, Mr. President.
Without objection, most certainly we will journalize that invocation and thank the senator for filling in this evening. Appreciate that. All right, has everyone recorded their presence? If so, the clerk, I was wondering, all good. The clerk will take the call. With 42 members of the chamber and a quorum being present, the Senate of Maryland is again back in session. All right, no resolutions today, but do we have any guests? Any guests? Yes, recognize the senator from District 9.
Thank you, Mr. President. Colleagues, I'd like to introduce the doctor of the day, Dr. Sunny Goel from District 9A, an ophthalmologist with LASIK eye surgeon, and accompanying him is the student from Johns Hopkins, Russell Calderon.
Excellent.
Well, thank you so much. Let's give them a warm Senate welcome.
Thank you for being here. Thank you for being here. Any other introductions today? Other introductions? Recognize the birthday senator from Montgomery County.
Thank you very much, Mr. President. For my birthday, one of my childhood friends came up just because we're going to be here until midnight, so I wanted to show him exactly what's happening, but it's great to please help me welcome one of my dear friends, David Dorefsky.
Welcome, Senator, welcome. We won't hold your relationship with the senator against you. Don't worry. Yes, recognize the chair, senator from Howard County.
Thank you, Mr. President. As the resident old Boy Scout, I believe there are some scouts here. If they could, oh, hey, how are you? From, I guess, the Annapolis area, is that correct? 422 Annapolis, and we welcome them here tonight. Excellent.
Welcome to the Scouts. Welcome 422. Thank you all for joining us. All right, any other introductions? If not, so be consider the reading of the journal from the prior legislative day. We've got a lot of work to do. We got a lot on the table. We've got we'll probably do 2 sessions tonight, so we'll have maybe a small break in between, but we're going to get through as much as we can and take it from there. So let's start with introduction of bills. We'll start with calendar 24. These are first reading House bills. Clerk will read the first bill.
Senate Bill 14, Delegate Foley, County Board of Education, bullying, harassment, or intimidation, information collection and reporting requirements.
Majority Leader moves so be considered the reading of the bills. They are referred to their appropriate standing committees. We've got calendar 25. Clerk will read the bills.
House Bill 83, Delegate Bartlett, Family and Law Enforcement Protection Act.
Majority Leader moves so be considered the reading of the bills. They are ordered to their standing committees. Calendar 26. Clerk will read the bills.
House Bill 305, Baltimore County Delegation, Baltimore County Nuisance Actions Community Association.
Majority Leader moves so be considered the reading of the bills. They are also to the standing committee. 27. Clerk will read the bills.
House Bill 16, Delegate Phillips, Correctional Services, Maryland Parole Hearing, commission members and hearing examiners, judicial proceedings.
Majority Leader moves again, so we consider the reading of the bills sent to their standing committees. Two more. Calendar 28. It's clearly crossover. Clerk, read the bills.
House Bill 470, Delegate Boafo, Digital Assist in Blockchain Technology Task Force Establishment,
blockchain.
Finance.
Blockchain. Uh-oh. All right, Majority Leader moves, so we consider the reading of the bills. They are ordered to their standing committee. And calendar 29.
House Bill 130, Delegate Ruff, Task Force to Study Deed Fraud, Judicial Proceedings.
All right, Majority Leader moves, so we consider the reading of those bills. They are all ordered to their standing committees. Let's go ahead and start with our layovers, see where we are with our layovers. We'll start with layover calendar number 35. Clerk will read the bill.
Senate Bill 932, Senator Harris, Consumer Protection, Social Media Platforms, Display of User Location. Question is the adoption of the one committee amendment and the favorable report.
All right, question remains on the one committee amendment. Any discussion of the amendment? Yes, recognize the Senator from District 1.
Mr. President, I have an amendment at the desk.
Senator, we're not quite there yet, but we'll get there in just a moment. We have to take up the committee amendments first. Anything on the committee amendments? Any objections to the committee amendments? Without objection, the committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Recognize the Senator from District 1 has an amendment. Pages will collect and distribute the Senator's amendment.
Thank you, Mr. President.
Senator, there's just a moment to
I'm
get
gonna
up on the board.
wait for them to pass.
Almost there. Senator may proceed.
Thank you, Mr. President. This amendment will actually strike city and substitute state, province, or other compatible subdivision. The reason behind this amendment is that while we understand the purpose of this bill, the last thing we want to do is say a particular city. We think that saying what state it is in, and say in this case Maryland and the United States, is broad enough to protect women, anybody who's would be possibly retribution would be coming for said post. So with that, I move the amendment, Mr.
All right,
President.
Senator moves the amendment. Let's hear from the floor leader.
Thank you, Mr. President. We'll take this as a friendly amendment.
All right, committee sees it a friendly amendment. Check from Senator from District 11.
Thank you very much, Mr. President. I also have an amendment.
Oh, 1 second, just one moment, Senator. Any objections to the Senator from District 1's amendment? Without objection, the amendment is adopted. Recognize the Senator from District 11 has an amendment. Pages will collect and distribute the Senator's amendment. All right, Senator may explain the amendment.
Thank you very much, Mr. President. So we wanted to dig a little deeper and get a little more specific in the kind of people who, people who may not want to have their location identified under this legislation, and that has to do with survivors of domestic violence and those whose addresses are being de-identified by the Secretary of State's office. So that's what this amendment does. It further protects this particular group of people who don't want to be found.
All right, Senator moves the amendment. Let's hear from the floor leader.
Thank you, Mr. President. We appreciate the concerns that the Senator has raised, and we'll also take this as a friendly amendment.
All right, excellent.
Lots of friends tonight.
All right, any recognize the Senator from District 9?
I just had a question for the maker of the amendment.
Senator may proceed.
So does this cover, we've now got, a couple years ago we did the judges de-identifying their personal information. This year we're doing legislators. Does this cover the legislators too?
It does not. So this just covers the people whose addresses, who are part of the address confidentiality program through the Secretary of State's office.
But what I'm saying is that now we're going to have if the bill passes the House, then we'll have a program through the DLS where the legislators can opt to have their addresses screened as well.
So this is not necessarily, this is for people's, as I understand the bill, it makes social media companies have to post where someone is posting from. And this would not allow them to identify that someone who is part of this address confidentiality program is doing so from the state of Maryland, per se.
So
Because
I'm
somebody
fine,
who's
I'm fine with the amendment. I'm just saying that if we're replicating the confidentiality program for state legislators, it would make sense that we would include them as well.
Perhaps
So,
that's another amendment, but
okay.
that was not my interest or focus, to be honest.
Thank you.
All right, on this amendment, recognized senator from 37th District.
Thank you, Mr. President. I just have a question for the amendment maker.
Question for the maker of the amendment. Senator may proceed.
So I want to make sure I understand. So the amendment requires a person to operate a social media platform to establish a process to enable a state user to make the certification described in section 2, Roman numeral 2 of this subsection. And that is so it includes minor? It says, the first paragraph says in line 9 after minor. So the minors are already included in this.
My understanding is that the minors are already exempted from this bill, and this requires the process. So the the social media company would have to develop that process in coordination with the Secretary of State's office. Yeah. So originally when I was thinking about this, I was thinking, well, the Secretary of State's office could just give the list to the social media company, but that is not a good idea. So they will have to figure out whether, for example, the Secretary of State's office would get in touch with the people who participate in that process and allow them. They would have to figure out the process that makes both sense both procedurally and safety-wise.
Sure, and thank you, and I support the amendment on 200%. I think it's a great amendment, right on point. But the point of me standing up and asking questions is I wanted to bring up the issue of child abuse. And is child abuse, if minors are already exempted, do they have a way to decide whether they want to be identified or not? So the abused children, how are they covered by this?
I'm going to defer to the floor leader on the bill, if that's okay.
Please, Senator.
Senator, if you could repeat the question.
I just had a quick question about this amendment, which I support 200%.
Sure.
And we were talking about this process, and we were talking about domestic violence. Yeah. And I understand that minors have an opportunity to be exempted from the bill. I want to confirm that. And the point of me getting up and asking, because we were talking about domestic violence, I just wanted to raise the issue about child abuse and the victims of child abuse, and whether they would also be able to make sure that if they had a reason that they didn't want their identity to be disclosed, that they would have an opportunity with this bill to be able to protect their identity or their location.
I appreciate the concern that's being raised, but they're already exempt by virtue of being minors. So this is about, like, if you're on Facebook and you make a post, I think there are a lot of concerns that there may be foreign influence, on different Facebook posts and social media. It's merely to say, and I think with a good senator from Western Maryland's amendment, that it'll just say that the post came from the state of Maryland, and that's it. If you're a child and you're on Facebook, one, you have to be over the age of 13 anyway, but two, children would be exempt from having their location. And the location is based on your IP address. So Facebook could know where you are based on your IP address. So there's really not a lot of relevance on the issue with respect to child abuse, because minors would be exempt anyway.
Well, I appreciate that explanation. I just wanted to make sure, since we were bringing this up, that
Sure.
that was also considered. So thank you.
I appreciate it. Thank you.
All right. On the Senator from District 11's amendment, any further discussion? Any objections? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 932 is hereby ordered printed for third reading. Let's go to layover calendar 34. Clerk will read the first bill, or the bill.
Senate Bill 623, Senator Watson, retail tobacco businesses and established a premium cigar lounge alcoholic beverage license, a Maryland Premium Cigar Lounge Act of 2026. Question is the adoption of the one amendment offered from the floor by Senator Hester.
Our question is on the floor amendment from the senator from District 9. Any further discussion of the amendment? Any objections to the amendment? Recognize the floor leader.
Yeah, I think the senator from District 9 wanted to withdraw that amendment. And there will be another amendment? No? Okay. Maybe not. Hello?
Well, question is on the amendment. Let's check with the senator from District 9. Yes, what purpose does the senator rise? Recognize the minority leader.
Just because we're in this, can the amendment be explained again so that we're all on the same page on what this is going to do?
All right, let's go back to the senator, the maker of the
Thank
amendment.
So the amendment says that in Howard County, the priority is going to be given to 2 established licensed tobacconists who have been in business for the preceding 5 years. And so I think there's some confusion about the drafting, but there's 2 amendments, and this one is for Howard County, and I would like it to be considered favorable.
Okay, so question remains on the amendment. Any further discussion of the amendment? No further discussion. Recognize the senator from District 8.
Thank you, Mr. President. I have an amendment.
Oh, okay, one second. We just have to let's take care of this one first. On this amendment, is there any further discussion, any objections to the amendment?
Mr. President.
Recognize the minority leader on the amendment.
The maker of the amendment, please yield.
Will the senator from District 9 yield to a question? Senator may proceed.
Thank you very much. So just in explaining this amendment again, this was statewide legislation that was going to allow these cigar lounges. You're stating, or it's being stated, that there are 2 establishments that are already in Howard County, and you want, and the amendment wants to make sure that those 2 establishments can remain based on the legislation and not have to apply or apply under the new guidelines, just to be clear.
So my understanding is that in some counties, there are licensed tobacconists who have been doing the BYOB, and going forward, those will be grandfathered in. In Howard County, they've just been doing like no alcohol, and so they will not be grandfathered in, any of them. But we're saying that Howard County gets 2 licenses for the entire county, given our size, and that we feel that those 2 licenses should go to the tobacconists who have been there already and been following what they perceived as the fair rules of play. And so we would like the 2 licenses to be preferred preference to go to somebody who's already been there, not somebody new coming in from outside the county.
Okay, so they would still go through the same process with the local Board of Commissioners or whatever that might be in Howard County, apply for the license, but in a sense, you're asking the local Board of Commissions to give deference to them so that they could get that license.
Exactly.
Okay. All right. Thank you very much. Thank you, Mr. President.
All right. On the amendment, any further discussion? Any objections to the amendment? Without objection, the amendment is adopted. Recognize the senator from District 8. Pages will collect and distribute the senator's amendment. Give us just a moment. All right, recognize the maker of the amendment.
Thank you, Mr. President. This amendment is in the same posture as the Howard County amendment that we just saw.
All right, Senator moves the amendment for Baltimore County. Let's check with the Vice Chair of the committee, floor leader.
Again, Mr. President, this amendment that we haven't seen, my chair haven't seen, the member is on the committee. I ask the body to reject this amendment.
All right, not see it as a friendly amendment. Let's recognize the chair of the committee.
Thank you, Mr. President. I had a conversation, a text conversation with the Baltimore County representative, and I did ask him to draft an amendment. I thought he was going to combine the amendment with Howard County. Apparently this is a separate amendment. We've not seen it, but I understand the concept.
Okay. Question remains on the amendment.
Yeah,
Question remains on the amendment. Any senators who have not yet spoken wish to speak on the amendment? We'll go to the senator from District 11, followed by the minority leader. Senator from District 11.
Thank you very much, Mr. President. It is the same exact amendment as we just approved a couple of minutes ago, and I will say that when we met as a delegation off the floor in our earlier session, the delegation voted to support that amendment.
All right. Recognize the minority leader.
Thank you, Mr. President. At some point, this brings up the question of how many other counties need to pile onto this as well, too. And I think that's what really should have been discussed. When we looked at this bill in committee, it was a statewide legislation. I mean, this is what we decided to do. It wasn't to be brought out here and have county after county after county decide to amend themselves out of it. And I agree. I mean, if somebody's been in business for a period of time, then maybe they should be the ones that stay there. But I don't know if there's any other counties out here that are in this same condition that want to make sure that their county, those establishments are treated the same way. So I would say we need to do something other than just continue to accept amendments, Mr. President.
All right, it's just looking at the time. We've recognized the senator from Montgomery County, and then followed by chair of the committee.
Thank you, Mr. President. I was just going to say I rise in support of the amendment. I can tell you one of the sincere concerns about this bill as introduced is that there will be large out-of-state entities in play looking to get these liquor licenses and open up large cigar bars in jurisdictions. The purpose of these amendments is to ensure that the local cigar shops that have been operating and serving these communities will have the opportunity to avail themselves of this license and not be exposed to big, large, out-of-state entities coming in, scooping up the licenses and putting them out of business. So I support the amendment.
All right. Let's check with the chair of the committee.
Thank you, Mr. President. I just want to correct something that my colleague from the Eastern Shore said. These last two amendments do not exclude these businesses in their counties. They're just asking that the existing businesses have priority for these licenses before these out-of-state companies can come in. I don't have a problem. Each of these counties took a vote and did this on their own. The rest of the counties we haven't heard from, and it's very limited, the number of licenses. It's one for every 150,000 of population. So for instance, in my county, we can have 3. We already have 2 existing. So in most counties, they'll have 1 or fewer. It's really not going to be a big influx, I don't believe. So thank you, Mr. President.
All right. Question remains on the amendment. Recognize. Are there any senators who have not yet spoken who wish to speak? If not, recognize the minority leader.
Thank you, Mr. President. I didn't think I had said that they should be excluded, but I agreed with what the senator from Howard County said. If there are some that are already operating, then they should be protected. They should be able to continue operating, which I think is a good idea. And Howard County, again, took a look at that. Baltimore County is doing the same, but there are 22 other counties here that may not have had the opportunity to meet, with their local officials to see if this affects a business in their county as well. I mean, maybe this amendment should be just drafted to say if there are any establishments that are already operating, that they would be, moved to the front and have first priority if they want it, not just on a county by county basis. So from that perspective, Mr. President, I would ask that we special order the bill until the next session and give either the opportunity for every county to pile on or the opportunity to get one amendment that would deal with this from a statewide perspective, that everybody would be able to protect the businesses that are in their districts.
All right. Senators made a motion. Senators made a motion. On the motion of special order, all in favor say aye. Opposed, nay. Appears the noes have it. So amendment's still before us. This amendment is still before us. Yes, recognize the minority whip on the amendment.
Mr. President, just a question, if I could ask maybe the floor leader about, before we vote this amendment.
The floor leader or the maker of the amendment?
I would like to actually ask the floor leader or the committee this question.
Vice Chair of the committee, floor leader?
I support Baltimore County having the local control to do this. In the bill right now, can my county, I have two, but Carroll County is the main county that I represent. We have cigar shops. We don't have anybody that's doing this because it wasn't allowed. Can my county, under the bill, adopt those same safeguards that we're asking for, that the amendment folks are asking, the sponsor and the county is asking for in this amendment? I'm not speaking clearly, I apologize. Go ahead.
To answer the gentleman's question, Mr. President, yes, absolutely. So one of the things that the committee made sure that local liquor boards, first of all, this is only given the authority to the counties, right? The county have to raise their hand and say, yes, we want alcohol served in our cigar spots. And then the county can also have regulation to say who gets them. I had an opportunity to see the amendment from Howard County. I talked to Howard County. I told them that they could go to their liquor board. What I got back from them was they don't necessarily have any assurances that their local board would take place. I'm not sure what the case is in Baltimore County. This is the first time I've ever seen it. I don't know what their situation is. But yes, bottom line is local liquor boards can prioritize the existing businesses in their county.
Okay, so that's great. I appreciate that answer. I have, so again, my liquor board in Carroll County would have the control because we're dealing with liquor going into a cigar establishment. That's good to know. I trust my liquor boards, so that's great. I think they'll. I'm not saying I'm not attacking anybody. I mean, it's just different dynamics, but I'm comfortable with that. Is the committee supportive of this amendment? Are we supporting the amendment as the committee?
Yes.
Okay.
Reluctantly,
If
yes.
there was a need if there is a need, okay, Mr. President, I appreciate the answers, and I wasn't going to say anything on this. I know it was out of our committee. I just would love to know that if we need to come back as a county over here, any of our counties, that we could come back next year, much as we do with alcohol. Well, this is alcohol, so.
Precisely.
To get some sort of protection, although I am concerned about opening it up. So anyway, thank you, Mr. President.
All right. Thanks. Best of the Senate. We worked our way through. It doesn't appear that there's an objection from the committee. Any objection from the floor? Without objection, the amendment is adopted. Do we have any other amendments to the bill or its title? It appears we do. Here we go. All right. Senator from the
no,
38th.
it's not an amendment. It's just a question for the floor leader.
Senator, we don't really have anything before us because we're still on second reading, open to amendment.
Okay, I was just trying to understand the process on the liquor boards. So.
Okay. Yeah, it'll come back up on third reader, but if we don't have an amendment before us, we don't have anything before the body. Any other amendments to the bill or its title? Seeing none, Senate Bill 623 is ordered printed for third reading. All right, let's go to layover calendar 33. Clerk, read the bill.
Senate Bill 84, Senator Kramer, State Personnel Collective Bargaining Graduate Assistance. Question is the adoption of the one committee amendment and the favorable report.
All right, question is on the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Recognize the senator from District 2 on the report.
Thank you, Mr. President. Colleagues, I have an amendment.
Oh, one moment. On the report, any discussion or objections to the amended report? Without objection, the amended, favorable report as amended is adopted. Senator from District 2 has an amendment. Pages will collect and distribute the senator's amendment. Senator may continue. Yep.
Thank you, Mr. President. And I appreciate the conversation with the floor leader earlier, and I appreciate him enlightening me and educating me as far as the graduate assistants are also employees. And so basically what this amendment does is just clarifies that and says as part of the graduate student's education is employed as a teaching administrative or research analyst. So that's the amendment, and I believe it would be a friendly amendment, I hope, and I move the amendment.
All right, the senator moves the amendment. Any further discussion? Let's hear from the floor leader. Floor leader.
Yeah, thank you, Mr. President, and I appreciate the dream machine that this will be a friendly amendment, But colleagues, the bill is very specific with regard to the definition of a graduate assistant. The language that alters that definition in this amendment creates confusion and, for what it's worth, mischief. So I would ask that the body please resist the amendment. It is not needed. It serves no purpose. The definition of a graduate assistant is in fact very clear in the legislation before you. So with that, once again, Mr. President, I would ask that we resist the amendment.
All right, Senator, a question remains on the amendment. Any discussion of the amendment? Recognize the minority leader on the amendment.
Thank you very much, Mr. President. For the floor leader, just going through the definitions as you described, graduate assistant means a graduate student at the University of Maryland College Park or the University of Maryland Baltimore County who is a teaching, administrative, or research assistant on a comparable position, fellow or postdoctorate intern. So it talks about the graduate assistant very specifically being a graduate student, right? It does not mention employee.
The definition, as you read, is the definition in the bill.
Right, and it does not mention employee in that definition, correct?
It's the definition is as you just read it
As
to
the
the
senator read.
body.
As the senator read. As the senator read.
I don't want to have
As
to
the
read it.
gentleman read to the body. Thank you, Mr. President.
I'll take that as it does not have the word employee in it because that's what the amendment chooses to do. Collective bargaining is, do you want to tell us what collective bargaining is first? if you don't
Does
mind?
the floor leader
Mr.
wish to?
Floor leader wish to explain what collective bargaining is first? Or I could read the sentence that it is. But
The bill that is before us would afford those graduate assistants that are included now in the amended bill the opportunity, should they choose to avail themselves of the opportunity to bargain collectively, which means they can work together and work with a bargaining unit that will represent their interests in negotiations with the university systems that are included in the amended version of the bill.
All right. An easier definition of collective bargaining is a good faith negotiation by authorized representatives of employees and their employer. Right? That's the definition on page 1 of the bill. A good faith negotiation by authorized representative of employees and their employer. So when you're talking about what a graduate assistant is, you've said the graduate assistant is a student, not an employee, as the amendment would offer. So why not clarify in the definition of graduate assistant that they are employees and then allow them to collective bargain as the bill suggests?
And I appreciate that we do not have in the bill the definition of an employee, but as the gentleman just pointed out, evidently it is not necessary because under the definition of collective bargaining that you just read that the gentleman just read to the chamber, it defines collective bargaining as with employees and employers.
Correct.
Thus negating the need to have any further definitions or language added into what we currently have before us.
Actually, even more so of a reason to include employee in here because the definition of a graduate assistant calls them a student, not an employee. The amendment before you, before the body, would make it very clear that a graduate assistant is not only a student, but an employee, and therefore allow them under the definition of collective bargaining to be able to collective bargain.
And we have no definition in the bill of an employee. Without that definition, it could create absolute mischief with the bill, And the purpose of the bill is to have clarity, and adding this amendment and that language does just the opposite, and it creates confusion. But I appreciate the good thoughts of the gentleman.
Thank you for clarifying my point, Mr. President, on the amendment. You know, again, I
On the
think
amendment, Senator may proceed.
I think it's very important that we provide that clarity. And, you know, this amendment was brought to us by some of the organizations that would be involved in this, and said that there is, you know, not just here in Maryland with respect to this bill, but national concerns on whether graduate assistants are actually employees or students. So that's the big question here. Are they a student or are they an employee? This amendment actually helps out the bill by clarifying. It says that the graduate student would be considered an employee, therefore would be able to participate in the good faith negotiations of collective bargaining. I think without this amendment, there's going to be concern on whether graduate students can actually form together to be part of a collective bargaining agreement. So if the floor leader does not want to accept that clarity, I guess that's fine. But I would imagine that we will be, I know the bill moves it out till 2028, so we won't be dealing with it next year, but we'll probably be dealing with it at some other point. So I would still support the amendment. Thank you, Mr.
Thank you, Senator. Recognized Senator from the 37th District on the amendment.
I just have a quick question for the floor leader.
Will floor to yield. Senator may proceed.
So the amendment was described as being mischievous, right?
I'm sorry, repeat that if you would.
Did I hear correctly? The amendment was described as being mischievous, or there's mischief behind the amendment?
My concern is that it would definitely create mischief.
Isn't it true that collective bargaining for graduate students has been shot down by the National Labor Relations Board within the last 10 years?
I am not aware of that, and what I could share with the body is that the overwhelming majority of Big Ten schools, of which the University of Maryland is a part, afford their graduate assistants the opportunity to bargain collectively. And in fact, Ohio State and the University of Maryland are the only two in the entire Big Ten that have an absolute no policy either at the university level or the state level to afford graduate assistants the opportunity to participate in collective bargaining.
Well, thank you for that. They haven't done so well in March Madness. Maybe they're doing better for your argument. You got me thinking about sports. But getting back to the National Labor Relations Board, this is an issue that's decided ultimately when it's contested. It goes to the National Labor Relations Board, and it has been held that graduate students could not, in fact, collectively bargain because they weren't employees. Later, that changed. This has been an ongoing legal battle, and in order, if you really want this to go forward, if the proponents really want this to go forward, then they ought to address that issue with this opportunity in the legislation. And the amendment just simply defines what graduate students are. They're employees. So when it's challenged in court, they're defined as employees by the bill. So it's not a nefarious or mischievous amendment. It just clarifies what the graduate students would be if this bill is going to move forward. And that issue of whether they are an employee or not is the crucible that has been used in litigation. It's more than 10 years. It's been going on for about 20 years. So if you have Google and you have got your computers open, colleagues, I'd urge you to take a quick look, search National Labor Relations Board and graduate student collective bargaining, and you'll see plenty of information about why it's very important to clarify this in this bill through the amendment. Thank you, Mr. President.
All right, thank you, Senator. All right, on the amendment, if there's no further discussion, all in favor of the amendment say aye. Aye. Opposed, nay. No. Noes have it. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 84 is hereby ordered printed for third reading. All right, let's go to Senate Bill, or excuse me, layover calendar number 37. Clerk will read the bill.
Senate Bill 618, Senator Watson, Public Ethics, Members of the General Assembly, State and Local Government Employee Exemption. Question is the adoption of the 2 committee amendments and the favorable report.
Questions on the 2 committee amendments and the favorable report. On the amendments, any discussion? Any objection? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Yes, I recognize Senator Minority Leader.
Thank you, Mr. President. Have an amendment.
Senator has amendment. Pages will collect and distribute the senator's amendment. All right, Senator may explain the amendment.
Thank you, Mr. President. Just to refresh, this was the bill that, again, talked about legislators working for local governments and actually the state government as well, too. And there was a number of conversations that occurred. The Joint Ethics Committee heard some of this on Friday and came up with a number of suggestions that the committee could look at as they moved forward with the bill. Again, because we were not really in a legislative hearing where we were producing amendments or anything like that, we were just actually looking at one small change that that was presented to us. But a number of good ideas came out. And one of them we were talking about a little bit earlier today on what type of jobs legislators could get in government. And we wanted to be very specific to say that they had to be merit jobs, that they actually had to be advertised, that they had to have a certain period of time on which applications could be accepted, and go through a hiring process to make sure that we were not doing anything that would kind of upset that prestige of office. That, now again, is rather than it being before, where we're allowing individuals that worked for the government to be elected, which makes complete sense. If you're out there, you're working, and you decide you want to run to be here and get elected, that makes sense. This is opposite. This is said you've been elected, you're now state legislator, and now you're going to go and get a job with the state, with the county, with a municipal, any one of those forms of government. And there's big concern about what these jobs might look like. There's concerns that these jobs might look like a county executive decides that he or she may want a number of senators working in his or her administration, and put out these jobs that were out there that may be narrowly defined to make sure that they went to a senator or a delegate. Very concerning that you could end up being in a position where a number of legislators are working in these forms of government. So this amendment just states that the individual would not go into an at-will or not be an at-will employee. That simply it would be a merit job. It would have to be competed for. It could not be an appointment. In other words, the governor could not offer a job to a state senator and say, I'd like you to be my deputy chief of staff. Or the governor could not say to a state legislator that I would like you to be the assistant secretary at DNR. This would have to be a job that is not at will, meaning that, as we all know, there's appointed positions within every administration. And this says you can't take one of those jobs. If there is truly a job that makes sense, that you're skilled at, and that you want to apply for, that's one thing. But to have a brand new county executive, for instance, in a certain county, say that I want certain senators to work for me and create jobs, that's where we're going to lose this. And that's where we're going to run into potential corruption. That's where we're going to run into losing the public trust by having people work in jobs that were created for them. So this would be very simple, and it would just say that they they cannot accept an at-will job. It has to be based on merit, and I would ask to move the amendment.
All right. Senator moves the amendment. Uh-oh. Do we need napkins? Nope. Okay. All right. Senators move the amendment. Recognize the floor leader.
Thank you, Mr. President. And, you know, in the future, when someone wants to put an amendment on my bill, I hope they extend me the courtesy of having a conversation before. You're either merit or at will. You cannot be both, Mr. President. And merit and at will are both competitive. This provision is not needed in this bill, and I ask I ask the colleagues to resist this amendment.
All right. On the amendment, further discussion on the amendment. All in favor of the amendment?
Mr. President.
Yes, I recognize. Any senators have not spoken wish to speak? If not, recognize the maker of the amendment.
Thank you very much. First, and let me apologize. I have about 7 amendments on my desk, and I apologize that it did not get to you.
The senator.
Get to the senator, the floor leader. But that still doesn't take away from the fact that, as the senator mentioned, there are either at-will jobs or they're merit jobs. And at-will jobs is the concern that the Joint Committee on Ethics had when we met on Friday, that these jobs would be handpicked by leaders of local government. And so this is a very simple amendment that just says that's not the type of job you can take. And I don't think that that was the intention of anybody in looking for jobs or in what we've seen. I think the intention is that, as the floor leader has mentioned, that individuals are uniquely qualified based on the years of being down here to take jobs in local government, providing those jobs are true jobs that the government needs and not jobs that are at will, where they are at will of whether it be a county executive, a mayor, or the governor, anybody that we are allowing to hire legislators from both chambers. So simply make it, if it is truly a job that is out there and competitive, then this amendment makes sense. This amendment continues to build on public trust. This amendment continues to keep us out of trouble when we get to have to look at, when the Ethics Committee has to get to look at these exemptions that we're being asked for by legislators, to make sure that it's very clear whether or not it was a merit job or an at-will job. With that, Mr. President, I still think it is something that we need for public trust, and I ask for a roll call.
All right. On the amendment, any further discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 27 votes in the negative, the senator's amendment fails. Are there any further amendments to the bill or its title? Yes, recognize senator from the 35th district has amendment. Pages will collect and distribute the senator's amendment. Senator may explain the amendment.
Thank you, Mr. President. This amendment simply says, on or before January 20th each year, the Joint Ethics Committee shall post on the General Assembly's website a list of each legislator who, according to the most recent financial disclosure statement, has been employed or is employed by the state or a local government. To me, this amendment increases transparency, and it's in the spirit of the Ethics Committee meeting we had in the Silver Room the other day. That was, I guess, held Friday, where we were just trying to look at, certain guardrails. This is transparent. You can look at right on the website. It'll be easy to find, where you want to dig through a bunch of reports, and you can see who all works not only as a senator or a delegate, but also works at another level of state or local government, and what that position is. So this is a clear, transparent amendment request. And I'd like to move the amendment.
All right, Senator moves the amendment. Let's hear from the floor leader.
Thank you, and I appreciate my colleague giving me a copy of the amendment before. Colleagues, this is redundant and not necessary. We all know as legislators we have to file 2 types of disclosures every year: public disclosure of interest and the financial disclosure. The public disclosure, a legislator must disclose to Ethics Committee any representation of a person for compensation before a state or local government agency, except a judicial, quasi-judicial proceeding. Representation of a state or local government agency for compensation, financial or contractual relationship with a state or local government in the state. This is public information that anybody can query, and probably everybody in here has been queried at one time or another. So, colleagues, I ask you to resist this amendment. It's not needed, but I appreciate my colleague. Thank you.
All right. On the amendment, any senators who have not yet spoken wish to speak, recognize the minority whip.
Mr. President, I really understand the why the bill is, why this has engendered so much conversation and the motives behind the bill. I think all of us that are sort of in our middle-aged years deal with the challenge of being a state legislator, trying to do a good job, and also trying to have alternative employment or additional employment. I think this amendment would really be a good gesture, and I support the senator's amendment because I think it just says we're gonna do this, but we're gonna make sure it's just very clear and above board. So I don't know if a roll call's been asked for, but I asked for a roll call, and I do support the amendment.
All right. Any senators who have not yet spoken wish to speak, recognize the maker of the amendment. Oh, I'm sorry. Yes, recognize the senator from Montgomery County.
Would the maker of the amendment yield for a quick question?
Senator may proceed.
So I used to work for the state, and I was employed before I ran for office. So based on this amendment, would I be listed?
I believe you mean at a local, you work for a different level?
Yeah, so I'm wondering, because right now you're saying that anyone, so the minority leader said that they had no problem with people who were in a state or a county position and then ran for office. And the way that I'm interpreting this amendment is whether I was working in a state agency for 50 years and then decided to run for office, now I'm part of this. Is that right?
That's my intent, to have everybody a part of it. And let me tell you why I actually have experience with that. When I came to the legislature, I served in Hartford County government as agricultural specialist. So I stepped away from that job a few years ago, but I certainly wouldn't mind if my name and that position was on a list, because I believe in full transparency. So if I still was in that position that I was in 3 years ago, I'd gladly have my name on here. It's easy to find for the citizens of our state to see who's working for different levels of government.
All right. On the amendment, any further discussion on the amendment? If not, the clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 29 votes in the negative, the senator's amendment fails. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 618 is hereby ordered printed for third reading. Let's go to layover calendar number 3636. Clerk, read the bill.
Senate Bill 890, Senator Guile, Insurance Premium Receipts Tax Exemption for Captive Insurance Procured by Nonprofit Hospitals and Healthcare Systems. Question is the adoption of the two committee amendments in the favorable report.
All right, question is on the two committee amendments in the favorable report. On the two amendments, recognize the senator from the 42nd District.
Thank you, Mr. President. I earlier today asked this bill be laid over, and that's why we're dealing with it this evening. I want to especially thank the chairwoman of the Finance Committee for facilitating a meeting this afternoon with all the stakeholders back in her offices. It was very productive. We vetted all the issues. We haven't reached a final decision. We need a little more time, so I request that this bill be special ordered until Wednesday.
All right. Senator has moved a special order bill till Wednesday. Recognize the floor leader.
No objection, Mr. President.
All right, no objection from the committee. Any objection from the floor? Without objection, the bill is special ordered to the appropriate time on Wednesday. All right, let's go to layover calendar 31. Clerk, read the bill.
Senate Bill 202, Senator Folden, Police Discipline Order to Show Cause. Question is the adoption of the two committee amendments and the favorable report.
All right, question is on the two committee amendments and the favorable committee report. On the amendments, on the committee amendments, any discussion? Any objection? Without objection, the two committee amendments are adopted. Question now is on the amended report. Recognize the senator from Baltimore County on the report.
Thank you very much. Would the floor leader please rise for questions?
Floor leader yield for a question. Senator may proceed.
Thank you very much. The amendment, it reads, a police officer who is denied a right granted by this section for which the denial is not eligible to be remedied by a trial board under 3-106 of this subtitle may apply to the circuit court for an order that directs a law enforcement agency to show cause why the right should not be granted. I'm curious, would you mind explaining?
The senator. Sorry, the senator. Would the senator mind?
I'm sorry, thank you. Would the senator, with the floor leader, mind explaining what the phrase for which the denial is not eligible to be remedied by a trial board under section 3-106 of the subtitle, what that means?
Sure, thank you for the question. Those that are covered under the Police Accountability Act would be those where they were disciplinary type measures that dealt with their performance within the job that was required punishment consistent with that. That amendment clarifies that this would be for acts of like whistleblower or things relative to their off-duty secondary employment that are not within the scope or purview of the Police Accountability Board.
And that's what's under section 3-106?
One second, I apologize. I mean, that is my understanding that that's what would be entailed in those type of incidents, but I want to make sure I don't give you a bad answer.
Oh, we can move on to the
Okay.
next question that I have. The next phrase is, may apply to the circuit court for an order that directs a law enforcement agency to show cause. Is a show cause order, is that like an interlocutory appeal?
No, it's an order held by a trial court.
It's not an interlocutory appeal?
Counsel is telling me no.
Are any other public employees or legislators who are being investigated for misconduct allowed to interrupt those investigatory proceedings with an interlocutory appeal by filing a claim in the state circuit court that certain rights are being violated?
This is not pertaining to misconduct.
Does any other public employee have the right to file an interlocutory appeal?
Well, I mean, I don't have that answer for any other employee. I mean, are you talking about any other law enforcement or anybody?
The senator. Is the senator.
altogether?
Is the senator.
Oh, senator, I apologize.
Talking
Senator,
about public employees.
I don't have an answer to that because it's so broad. This is very narrowly tailored and focused.
Does our criminal and civil legal system generally prohibit interlocutory appeals of non-jurisdictional issues, including factual defenses?
Can you repeat the question, please?
I said, does our criminal and civil legal system generally prohibit interlocutory appeals of non-jurisdictional issues, including things like factual defenses?
Well, seeing as how the council was advised this is not an interlocutory appeal, that would not apply.
I disagree with counsel, but okay.
Same counsel we get advice from, Senator. Same
Understand.
counsel.
Is there any reason this bill would not apply to an investigation or review of misconduct complaints involving members of the public?
No, because that would be a disciplinary matter.
And my last question that I have for you, weren't the contents of this legislation repealed by the Maryland Police Accountability Act of 2021?
Are you asking if there was something specifically prior to this?
So does this bill bring back a provision that was previously in the Law Enforcement Officers' Bill of Rights?
Yeah, I mean, it could be something
yes?
similar, but Senator, it could be something similar, but there was nothing specifically worded under the Leobar that provided for this type of mechanism that was non-disciplinary related to ask for the order to show cause.
Was that a yes or a no?
So by your wording, no.
Thank you very much.
All right, question remains on the favorable report as amended. Any discussion, any further discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 202 is hereby ordered printed for third reading. Let's go to Senate Bill Special Order Calendar 57. Actually, hold on, I'm sorry. Not special order, I'm out of order. We have second readers. We have a report coming out of Finance. This is report number 32. Clerk will read the bill.
Senate Bill 947, Senator McCray, Maryland Transit Administration Reform Act, favorable with 2 amendments.
All right, recognizing the Vice Chair of the committee as the floor leader.
Thank you, Mr. President. Senate Bill 947 as amended makes changes to the structure, authority, and responsibilities of the Maryland Transit Administration by repealing the Baltimore Regional Transit Commission and instead establishing the Board of Directors for Baltimore Core Transit Service and Commuter Services Advisory Board. Additionally, MTA must contract with the Baltimore Metropolitan Council to complete a technical study regarding the creation of the Rail Authority. There are 2 amendments. Amendment number 1 is technical. Amendment number 2 strikes provisions exempting certain MTA projects from provisions and procurement law, removes a tort cap established by the bill, and removes provisions relating to quick take authority, including a proposed constitutional amendment. I move the adoption of favorable committee report.
All right.
I move the amendments and adoption of favorable committee report. Sorry about that, Mr. President.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 947 is hereby ordered printed for third reading. Let's go to Budget and Tax, report number 16. Clerk will read the bill.
Senate Bill 148, Senator Kagan, Income Tax Subtraction Modification, Public Safety Employee Retirement Income, supporting our 911 Specialist Act, favorable.
Recognize Senator from District 6 as the floor leader.
Thank you, Mr. President. Senate Bill 148 expands eligibility for the Public Safety Employee Retirement Income Subtraction Modification to include specified retirement income attributed to services as a 911 specialist. Mr. President, there is no amendments. Move favorable to adopt to the committee report.
All right, floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 148 is hereby ordered printed for third reading. Let's now go to Special Order Calendar 57. Clerk will read the bill.
Senate Bill 165, Senator Brooks, Environment On-Site Wastewater Systems Requirements for Inspection and Pumping Services and Implementation Dates. Bill is on second reading and open to amendment.
All right, question is on, question is whether there are amendments to the bill or its title. Prior amendment had been withdrawn. Recognize the minority whip.
Mr. President, am I able to ask the floor leader to yield for a question?
Technically, we do not have anything before us. Okay. Is there an amendment that the senator has?
I do have an amendment.
All right, let's get the amendment up and running. The pages will collect and distribute the senator's amendment. Then we will have something before the body.
My hesitation, Mr. President, was I was not sure if we were going to try to work something out. It sounds like no, so yeah.
Well, we'll see. We'll see where we are. Let's. Question is on the. All right. Senator may explain the amendment.
So this amendment, it looks somewhat lengthy, but really what it's trying to do is make it clear that there's a difference between advanced treatment units and other types of non-septic systems and non-septic tanks and septic tanks. And one of the mistakes I think in this bill, based on my reading and me talking to a number of people who are very knowledgeable in the industry, is that it treats bats and regular septics like they're the same thing. And the view of this amendment is simply trying to say that in coordination with an individual who's licensed under Title IX, Subtitle 11A of the Environment Article to perform property transfer inspections, an individual who's licensed under that subtitle to perform pumping services shall pump out each on-site wastewater system associated with a property transfer inspection under this article, and that the State Board of On-Site Wastewater Professionals shall adopt procedures governing the pumping of advanced treatment units and other non-septic tanks. I think the goal of this amendment is to make sure that pump outs are happening with the inspections, and that we're treating the two systems, we're treating these different systems, that there's the right regulations for the different systems. And I am certainly out of my depth on explaining this, but it's really almost, I view it as like a technical amendment. I don't know that it's going to be taken that way. But anyway, I'd move the amendment, Mr. President.
All right. Senator has moved the amendment. Check with the floor leader.
Thank you, Mr. President. Colleagues, I guess I'm dropping everything. I'm going to have to, I appreciate the minority leader giving me the amendment about 15 minutes ago, but I'm going to have to ask the body to reject this amendment. You know, we seem like we're not taking into consideration the need for this particular bill or the immediate cost that we're dealing with, and I think that this amendment is trying to do a study, is a delaying tactic. You know, we need to go ahead and move on this. This bill, SB 165, addresses a critical concern,
Mr. President.
and it cannot wait for a study, which would delay the necessary action that we need now.
Senator, just a moment. I think we may have double check that we have the right amendment up. Senator, the amendment that was 621 is on the inspections.
Mr. President, my amendment is 403621/1.
The other amendment.
I do. Oh, okay. I thought it was 165. I'm sorry.
All right.
That's the one I just got. Okay. Hold on. Okay. Oh, thank you. Okay. And of course, everything fell on me. Yeah. Okay, got it. Okay. Okay, yeah. Sorry about that, Mr. President. Okay. Oh, okay. Yeah. That amendment. The proposed extending the mandatory septic system, what it does, it would increase the deadline in the sewer disposal professional from July 1, 2026 to July 1, 2028, while mandating inspection for rental properties. Yeah, this would hold on. Oh, here we go. Yeah, this issue, proposed amendment, is that it would require MDE to consult with the Maryland Realtors on the development of all regulations implementing Chapter 419 of 2022 Those regulations extend.
Senator, apologies. I think that's the one that the senator withdrew. That's the withdrawn amendment. Is that correct?
Oh, okay. Yeah. Okay, thank you. Thank you, Mr. Chair. Okay, here's what MDE provided to us with these ideas came up into committee on the question of consolidating the pump out with the inspection as required by the amendment. MDE does not believe that there is a substantial benefit to pump outs occurring simultaneously with an inspection. Some conditions of a failing system might be missed in a pump out if it were to occur simultaneously. Additionally, simultaneous inspections and pump outs may present homeowners with difficulties in scheduling the two different companies at the same time. Yeah. In other words, one would need to pump out before they could do the inspection, and that would create a problem because you can't truly inspect until the pump out is done.
All right. On the amendment, if there any senators who have not yet spoken wish to speak, recognize maker of the amendment.
Mr. President, I'm not surprised that MDE opposes the amendment. I'd like to know what the committee thinks, because this is, when we hear that this is going to interfere with dealing with the problem, which is, I'm summarizing what I heard from the floor leader, I don't know what the problem is. And all my amendment is trying to do is saying, let's be sure we understand it's different types of systems and that there's a pump out that occurs in connection with the inspection at the same time, so you're not gumming up the works. And again, this is not a Justin Reedy amendment. I can say my own name. Media amendment I dreamed up myself. I mean, this is coming from people who work in the industry, who are just trying to be sure the bill makes sense. I, for the life of me, don't quite understand what we're trying to accomplish here. We've had 1 million gallons or millions and millions of gallons of sewage flowing into the Potomac River. I can't imagine that anything going on with septics is, and we're told that's going to dissipate. I can't imagine anything we have going on with septics is going to be any near that problem. So I keep trying to find out what's the problem we're trying to solve with the bill. And so this is really, I would just press my amendment to say that, I'd ask for a roll call. This is just trying to make sure that we have multiple types of septic systems, and we're trying to be sure we get that right kind of expertise for that, and we're trying to be sure that these inspections and pump outs happen in a way that makes sense with a timeline. So I would press my amendment, Mr. President.
All right. Let's see. Are there any senators who have not yet spoken who wish to speak? Recognize Chair of the committee.
Yeah, very simply, what MDE did tell us is what the amendment is proffering is simultaneous inspections and the like, and that in their view that doesn't provide any substantial benefit. On the other hand, it says that if you do it the way that the amendment suggests you do it, that there could be important things that are missed if you do this double inspection. So in a nutshell, that is basically where the committee came down. And yes, some deference to the Maryland Department of Environment, because as you acknowledged yourself, this is a fairly technical issue. You yourself had difficulty, the minority whip, had some challenges explaining the bill. And so not shockingly, the committee went to the experts, the folks most familiar, and they did not think that this particular amendment provided any benefit. And on the flip, that by doing this way, you could actually have some missed failures in the like. So that's best I think the committee can offer to the minority whip on this amendment. So for those reasons, I would support a red vote on this particular amendment. Thank you, Mr. President.
All right. Any senators who have not yet spoken wish to speak? Recognize the maker of the amendment.
Mr. President, I wonder if I could ask the committee chair just a follow-up question, if I might.
Senator Yield.
But again, the chair is not expert as you described. It's a very technical issue.
I do. I appreciate that, and I appreciate, as I said, I'm happy to acknowledge I'm not an expert either. Did the committee hear from industry representatives? And when I say industry, we're not talking about like Walmart or Amazon. We're talking about a lot of small business people, but they've got some representation. Did they take any input from the people who actually pumped the systems out for this bill?
Well, that was not, there was no testimony about this particular amendment during the bill hearing, which we had one. Nobody weighed in, proffered this amendment.
But on the bill, was there opposite?
Yeah, well,
what was the
that I'm going to
burning-
defer. The floor leader has the bill file in terms of who was supportive. I don't have that in front of me.
Mr.
but-
President, I guess my frustration is I don't understand why we need this bill. They're not nobody's able to been able to explain what's the problem we're trying to solve, and then we have amendments that come from people representing the industry, and that doesn't mean we should take them. I mean, obviously, but I just can't have a hard time getting an understanding of what this bill really does that's not being done now. It's requiring inspection and pumping and pumping when you have property change hands, but then why would we not just want to have that happen simultaneously? I know nobody wants to spend a lot of time on this tonight, and I apologize, but just trying to get some answers here.
All right, recognize the senator from the 43rd District.
Would the floor leader yield?
Yes, I will.
Senator may proceed.
Thank you. So just to address, the committee did in fact hear from a number of practitioners in this space. Specifically, we heard from Sewer Solutions, and the owner of this Superior Septic Services. He's had over 21 years of experience working on on-site wastewater systems, said that he fully supports the intent of this legislation to protect public health, groundwater, and consumers by requiring property transfer inspections and septic pump outs. These measures will significantly improve transparency and environmental protections across the state.
All right. Any senators who have not yet spoken wish to speak? If not, recognize the maker of the amendment.
Mr. President, I wonder if the folks who expressed support were perhaps going to benefit from this legislation, and there's nothing wrong with testifying for a bill you support because you'll benefit from it. But I'm really curious here because I hear from people who do this who say this bill doesn't make a lot of sense based on how they're structuring the timeline. And so, I mean, again, I would press the amendment because they're saying they support the aims of the bill, which is to reduce, groundwater being polluted. Well, who's not for that? But there's not a lot of evidence that that's going on right now. This is adding on more. This is adding on more cost to selling a property or buying a property. A lot of times realtors will tell you that this is a negotiated thing. If you're buying a house with a septic system, a negotiation about whether you add into the price that you're going to get it inspected and pumped out beforehand or not. And right now it's not happening at all. So saying that the pump out and the inspection happen at the same time is just to save everybody time and money. And so, again, I'll press my amendment and ask for a roll call.
So. Yeah.
All right.
On the amendment?
Recognize, excuse me.
Thank
let's recognize the floor leader, followed by the vice chair.
Okay, thank you. Yeah, I just speaking from a position, I've got a septic, and I've had it inspected, and then really, it's extremely difficult to do an inspection with prior to, before a pump out. You've got to pump it out. Then once you get it pumped out, then you can do the inspection. So it just make common sense to do it that way. It's extremely difficult to try to do the pump out prior to do the inspection prior to doing the pump out because you won't be able to find the whatever damage or whatever conditions that are there.
All right. Recognize the vice chair.
Thank you, Mr. President. The senator from District 5 asked about whether there were others who testified that didn't have a commercial self-interest. I just thought I would share for the body's interest who else testified in favor of this bill. If that's okay for the floor leader, I'll just run through the list really quickly. In addition to Maryland Department of the Environment, Arundel Rivers Federation, Back River Precast, Waterkeepers Chesapeake, Clean Water Action, Shore Rivers, Chesapeake Bay Foundation, Assateague Coastal Trust, Shore Rivers, and others. So there were a bunch. Thank you, Mr. President.
Thank you, Senator. All right. Recognize the senator from District 4 on the amendment.
Thank you, Mr. President. On the amendment, I guess May I ask the floor leader to yield, please?
Senator may proceed.
Yes, go ahead.
Thank you, Senator. So I vaguely recall this, and I'm going to apologize because I know I've been absent here the past day and a half, but when we passed the measures a few years ago, this body, with the BAT systems, the best available technology systems, wasn't that supposed to be the remediation, like that was going to solve all these problems that we were having with aging and outdated septic systems? Wasn't that the whole idea behind that bill?
Yeah. They're great if they're working well. This is just to make sure that the systems are working.
So and I'm going to have to ask for your indulgence, my good friend.
Sure.
So the way I'm reading this is that every time a landlord has a tenant that were to leave, so it could be frequently if they leave in the middle of their lease or they leave early, that the way this reads, every time there's a new tenant that comes in, the landlord would be required to have another inspection done, pay for another inspection. Is that correct?
This should be on an annual basis. Yes.
I thought that it had said
That's on an annual basis.
that
I stand corrected. An inspection is good for 3 years.
Oh, so if there's multiple tenants in a 3-year period, it's good for
3
that
years,
whole
yes.
3-year period?
Yes. Mm-hmm.
Okay. So this is just another, it's going to be good for 3 years, and then every time beyond that, so basically every 3 years, if you're a landlord, you've got to get your septic inspected.
That is correct, yes.
I mean, this is just another, look, I respect what you're trying to do, Senator, I really do, but this is just another fee on our business community and those people that are driving our economy and making it really difficult for them to continue to do services and business in this state. So with that, I appreciate your answers. Thank you.
Sure, you're welcome, sir. Well,
All right.
what we're doing, we're protecting the environment, and we're protecting the, particularly the environment, yes.
All right, recognize the senator from the 29th.
Thank you, Mr. President. I rise in support of this amendment, and years ago we always had a future before we came here, and I actually was a sewage disposal contractor, and I'd say that it was pretty easy. You had to go take a test, pretty much realized, it went downhill. But the issue was pretty clear, right? If somebody was asking if their system worked or not, right? Because if it got to be in the summer and they looked out in their yard and you saw 3 lines and you had grass green, you know what? It's pretty self-evident that it wasn't working, right? Because it wasn't going down, it was coming up. Other than that, right? If you pumped your septic out on a biannual basis and everything worked, there was no issue, right? You could easily tell there was indicators, usually would be coming the wrong way in your house, that things weren't working. But other than that, I think that there's a lot of expense for people in this if they've taken good care of their septic that is not necessary. Thank you.
All right. Question remains on the amendment. Any further discussion on the amendment? If not, on the amendment, the clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 28 votes in the negative, the senator's amendment fails. Are there any further amendments to the bill or its title? Recognize the minority leader has an amendment. Pages will collect and distribute the senator's amendment. All right, recognizing the maker of the amendment to explain the amendment.
Thank you very much, Mr. President. Obviously, there's been a lot of concern about what this bill does and why it's necessary. Being that this is very technical and not a departmental bill, this amendment would just simply strike the bill and make this a study, and would come back and require the Department of Environment to conduct a study on the necessity for pumping services of on-site wastewater systems during property transfer inspections and the environmental benefits of the practice. So this is something I think is very reasonable. Should the chamber want to move forward with it, at least let's get some information from the Department of Environment, since it wasn't their bill, and tell us through a study how this is beneficial and what would be the appropriate way to move forward with cleaning these septic systems at the appropriate time. So with that, Mr. President, I move the amendment.
All right, senators moved the amendment. Let's hear from the floor leader on the amendment.
Thank you, Mr. President. Yeah, I would ask the body to resist this amendment. It would prevent the individuals from getting a 2-year extension on getting their licenses. You know, so this this would prevent that. So yeah.
All right, on the amendment, recognize Senator from District 6.
As we have done many times, Mr. President, we have had bills and we've done studies many times over. And the studies that we have done, we have proved that through those studies we've learned a lot. Matter of fact, we move forward in ways that we could make a difference. Knowing that, Mr. President, doing a study with this type of project, I believe it can make a difference in time. And I believe with this study, with this amendment, we can move forward and find out more and better ideas to do the right thing for our people that do have septic tanks. So I hope we can move forward and vote green. Thank you, Mr. President.
All right, on the amendment, any further discussion? Recognize Senator from the 38th District.
Thank you, Mr. President. I rise in support of this amendment. I spoke previously on this bill. I mentioned that this has been a challenge, especially in Wicomico County. We have had a work group, with that included both public officials, our realtors, those that are actually involved and knowledgeable about these processes. And it's clear from this debate we've had so far that we're a little bit confused about how we're going forward with Senate Bill 165. And this amendment, and if you look at the wording, it looks at the Department of the Environment shall conduct a study on the necessity for pumping services of on-site wastewater systems during property transfer inspections and the environmental benefits of the practice. I think we talk about in this body about how studies and data is important in informing us on our policy decisions. So again, I urge a green vote for this amendment.
All right, question remains on the amendment. Any further discussion on the amendment? Any senators who have not yet spoken wish to speak, recognize the maker of the amendment.
Thank you, Mr. President. In the comments about the amendment, I wasn't sure how this reference to providers or contractors being prevented to getting their license in 2 years. Could you just explain what that, why this bill is necessary for those companies to get their license?
It's striking provisions in the bill that extends the deadline for the licensing for septic professionals. Mm-hmm.
Okay, I didn't see that in the bill that there was deadlines for those professionals, but
check out page 5 of the bill starting at line 11.
The uncodified language there?
Yes, making changes to chapter 419 of 2022.
Right, but those individuals are simply participating or working in consultation with the Department of Environment for adopting regulations. I don't see that them not being able to move forward with this legislation would prevent them from getting licenses.
Would you look at line 16 through line 18?
Okay.
Mhm.
Okay. So that just says if they want to provide this services, that at some point in time they have to be licensed, but making this a study would not prevent that from happening.
By this year, they would have to be licensed.
So are they currently not licensed now? Is that what we're saying?
And then, yeah, and then need an extension to the deadline.
So we're going to, in order to get these professionals a license, we're going to put in an entire bill that will essentially give them business, is what it sounds like. We're taking this group of professionals that isn't licensed, and then we're going to mandate all of these pump outs to give them business so they can be licensed for that?
Those requirements don't start until July 1st, 2028.
Okay. And so the amendment I have before us would provide a study that would be required by June 1st of 2027, and let the Department of Environment tell us why the pumping out of these septic systems is required as often as we have in the bill. So that would not change the licensing portion in Section 7, since that's been moved out to 2028 anyways.
Yeah, your amendments would strike that extension.
Okay, but it's not until 2028 anyways. So by then, we would have a bill, or we would have a study to tell us the necessity, because isn't that the bigger issue? Why are we making this requirement on all the rental properties and every residence at every single family home that makes a transfer? Why is that necessary to do that much pumping out and inspections of septic systems?
Would you repeat that, sir? Senator?
Yep.
That's not making sense.
My question was, it was stated that an important part of this bill was to license these professionals. And you're saying that it has to be done now, even though the bill was amended, that on or before July 1, 26 was amended to 28. All individuals who provide wastewater services in the state shall be licensed by the Board of On-Site Wastewater Professionals. So that's 2 years, is the way that it says. Anybody that provides this services must be licensed in the uncodified language.
I'll yield to my chair.
Yeah, Mr. President, we have in our possession in the committee the cross file, and so I think that some of these issues have been, we can continue the dialogue using maybe the cross file. So I'd move to recommit this back to the committee at this point, and then we'll work off the cross file, maybe work through some of these issues, Mr. President.
All right. Given the timing, I think probably makes the most sense. I don't know that we're going to get a third reader back in time, so we'll. Are there any objections?
Thank you, Mr. Chairman.
Without objection, we'll recommit the bill and work through it with the cross file. All right. Let's take up special order calendar number 54. All right. Clerk will read the bill.
Senate Bill 4, Senator Kagan, Charitable Organizations, Charitable Donation and Tax Exempt Status, Revocation, Keeping Charities Nonpartisan Act of 2026. Question is the adoption of the favorable report as amended.
All right, question is on the favorable report as amended. I believe we have some amendments coming, but on the report, any objection to the report? Without objection, the report is adopted. Are there amendments to the bill or its title? Seeing none. Amendments? If there's no amendments to the bill or its title,
There is an amendment.
recognize the senator from the 23rd has an amendment. Pages will collect.
No, I don't have the amendment.
Oh,
The sponsor has the amendment.
Sponsor amendment.
Use yours. Yes.
All right. Senator has the amendment. Recognizing the floor leader who has an amendment. Pages will collect and distribute the senator's amendment. All right, Senator may explain the amendment.
Thank you, Mr. President. I want to start by thanking our amendment office who worked so hard to help us navigate the right words to make our bills even better. I don't love this amendment, but there were concerns about the impact of Senate Bill 4 on our faith institutions and religious organizations. So I appreciate the senator from District 23. His version and my version were very similar. He's just asked that my version go forward, so I'd like to move adoption of the amendment that has just been distributed.
All right. Senator moves the amendment. Are there any objections to the amendment? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Recognize. Nope. All right. If not, Senate Bill 4 is hereby ordered printed for third reading. All right, let's go to, well, actually, can we ring the bells, Madam Secretary? And if we could do a quorum call.
Mr. President.
Has everyone recorded their presence? If so, the clerk will take the call. With 43 members in the chamber and a quorum being present, the Senate of Maryland remains in session. We're going to go to third reading calendar 67. We have 2 third reading calendars, and then we may break for just a few minutes and then return after that. So we're going to get through these 2, take a quick pause, and then jump back in. So on calendar 67, clerk will read the first bill.
Senate Bill 340, Senator Heddleman, Office of the Long-Term Care Ombudsman, mandatory appropriation.
Senate Bill 340 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 41 votes in the affirmative, Senate Bill 340 having received a constitutional majority is declared passed. Clerk will read the next bill.
Senate Bill 412, Senator Augustine, Maryland Department of Health Forensic Review Boards and Community Forensic Aftercare Program.
Senate Bill 412 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 412 having received a constitutional majority is declared passed. Clerk, read the next bill.
Senate Bill 455, Senator Rosapep, Economic Development Transformational Project Financing Program Establishment.
Senate Bill 455 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 43 votes in the affirmative, Senate Bill 455 having received a constitutional majority is declared passed. Clerk, read the next bill.
Senate Bill 475, Senator Sidnor, Criminal Procedure Evidence Protecting Artists' Creative Expression, PACE Act.
Senate Bill 475 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 33 votes in the affirmative, Senate Bill 475 have received a constitutional majority is declared passed. Clerk, read the next bill.
Senate Bill 489, Senator Lamb, Health Occupations, Physicians Trained in Foreign Countries, Exemption from Educational Requirements, and Limited License.
Senate Bill 489 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 43 votes in the affirmative. Senate Bill 489 have received a constitutional majority. Is declared passed. Clerk, read the next bill.
Senate Bill 496, Senator Hershey, Maryland Medical Assistance Program, coverage for the treatment of obesity.
Senate Bill 496 is on third reading for final passage. Recognize the Senator from Montgomery County.
Yeah, thank you, Mr. President. Colleagues, it certainly appears that the worthiness of a fiscal note is apparently in the eye of the bill sponsor. As we heard earlier today from our senator from Charles County, the bill before us has a potential fiscal note of approximately $185 million on an annual basis. And that is based on the fiscal and policy note that states that if MDH implements the coverage authorized under the bill, Medicaid expenditures increase by a significant amount, estimated at as much as $449.4 million annually. Now, 41% of that will come from Maryland general funds. That translates, once again, into a $185 million a year hit to our Maryland taxpayers. Now, I can assure all of you that the majority party in this chamber are all responsible fiscal stewards of our residents' tax dollars. However, we repeatedly hear from our friends in the minority party every single time a bill comes to this floor and there is even a remote fiscal note associated with that bill. So apparently, fiscal responsibility depends on who is holding the calculator with regard to their own sponsorship of legislation. Now, I will share with you, I voted for this bill in committee. But I don't think it should be lost on any of us as we go forward, at the very least, colleagues, through the remainder of this legislative session, that when our friends in the minority party decide to get up and start opining about a fiscal note and whether it is a worthwhile investment, that we all reflect back on Senate Bill 496 and the fact that it will have a dramatic, in fact, to be quite frank about it, Mr. President, I am not sure we have had a bill before this body this year with this kind of a dramatic fiscal note potentially associated with it. So I'm not quite sure yet what my vote's going to be on this bill. Certainly when we are looking at fiscal notes, we weigh what is the investment and the benefit for our residents when we pass that legislation. I think that's something all of you are going to have to reach down deeply and determine whether the potential of almost $250 million a year is worth that investment. I will leave that up to each of you to reach that conclusion. Mr. President, I thank you very much for this moment.
Thank you, Senator. All right, any further discussion on the bill? Recognize the minority whip.
Thank you, Mr. President. The fiscal note has been amended because the bill's been amended. So the fiscal note, there's not this fiscal note number anymore. However, yes, there are costs associated with anything we do in healthcare, as our committee knows full well. I'd like the body to know that according to a recent report that MedCai put out, the Hilltop study that MedCai has posted for us helpfully, that in the last few years, this was done a few years ago, at that time, this is actually pre-pandemic, diabetes and its complication in the late 20-teens were costing Marylanders over almost $5 billion annually. $5 billion with a B. And in addition to that, $2 billion in lost productivity at that time. One of the leading causes of our Medicaid costs is folks who have diabetes or who are otherwise overweight, dealing with things like heart disease, hypertension. So those are very, very expensive rising costs. Now, if the argument is we should go to more of a free market ideas where the drug companies all have to compete to serve these people, that's a different discussion. But with the Medicaid program, they have to decide how they're going to cover things. And I don't believe we want to sentence people who are perpetually overweight, dealing with lots of problems. There may be reasons in their community they don't have access to the kinds of things that would allow them to eat healthier. There's a lot of different issues that come up. And we've heard that many times. So we now have medications that could be very good at helping people to reduce that obesity, reduce diabetes, and other risks. Again, if you want to argue that our system is too expensive, it's probably correct. But this is like saying to somebody, hey, we know the problem you have, and we can help. So I would just say that this bill with the fiscal note is from when there's a mandate to do all of this, and the fiscal note also, as we heard in second reading, deals with the idea that over 25% of Medicaid recipients would be on this drug, which just seems quite far-fetched. We're all familiar with fiscal note challenges in the way that they can be, they're not very dynamic, they're static. And so this is talking about taking a piece of the massive Medicaid budget and having it go towards these drugs to reduce cost in another area. So just wanted to stand up and say, yes, we get it. It's funny, but this is actually a really serious policy decision to try to really look at how we can reduce long-term obesity and ill health in our state and help people who really are struggling. So I support the bill, Mr. President.
Thank you, Senator. All right, recognize this President Pro Tem.
Yeah, I'm sorry. With the floor leader yield, just one question. Yes, sir.
Senator may proceed.
Do we actually need this bill? Could Medicaid actually do this? I mean, you only got a May in there. Why are we signaling to our department this interest in this significant investment?
That's the important part we just said right there. We want to signal to the department to move forward with this.
Okay, so you are interested in, I think it was a $250 million investment in this, and so that's what you're supportive of?
The senator.
I'm sorry. The floor leader is interested in this investment of a $250 million in this particular piece of treatment.
Absolutely. In fact, I wish that we could have got the bill forward that would have mandated the coverage of these GLP-1 drugs, because I do believe that they are so important in making a healthier population. If we didn't go through this earlier, part of the testimony we talked about was chronic obesity is linked to some of the most expensive and debilitating conditions that we treat every day in our Medicaid system. Type 2 diabetes, heart disease, stroke, high blood pressure, sleep apnea, joint disease, fatty liver disease, kidney disease, and certain cancers. That's what we're aimed at with this drug. That's what we're aimed at with trying to manage chronic obesity. Not just the cost of what it is, but the savings from being able to have a healthier population and maybe get rid of some of the expenses that we're paying to try to treat all those diseases.
Thank you, Mr. Flaherty. Mr. President, I will say that there's so frequently that we get up on this floor and we talk about the importance of preventive care. We talk about how we can make investments today that are going to pay off in the future. And we really do support that. And so I support that too. I think that's important. And again, I think it's important that we hold on to that when we look at other pieces of legislation where we are doing that going forward. And I do really appreciate the fact that we are going to look to things that are going to have this long-term, larger impact, but understanding that it does require an investment in order to do that. I appreciate it. Thank you.
All right, thank you, Senator. All right, third reading, final passage. Any further discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not,
Mr. President.
Oh, yes, Senator from District 7 has.
Just want to explain my vote real
explain
quick.
his vote.
Yeah, I listened to the Senator from Montgomery County when he got up, made a great point. Then I listened to the Senator from Carroll County. He gave numbers, sat here, started Googling it, and sure enough, everything's telling me about how expensive obesity is. So here we are, we're going to spend, could be $200 million to save, and I've got 3 different sites, $4.3 billion annually, $4.7 billion annually, or $4.95 billion annually on obesity. So we're spending $200 million to save almost $500 or $5 billion. To me, that's fiscally prudent, is they used to say in the House. I think it's smart. It saves lives. I've seen it. I've seen people who've started taking this stuff. They've lost weight. Their health is much better. So the President Pro Tem has said, it's the steps we need to take to start saving lives and saving money in this state. So with that, I'll be voting green.
Thank you, Senator. All right, any further discussion? Any further senators wish to explain their vote? If not, the clerk will take the call. With 43 votes in the affirmative, Senate Bill 496, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 515, Senator Bidel, Health Services Cost Review Commission, Health Facilities Rate Setting.
All right. Senate Bill 515 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. 42 votes in the affirmative. Senate Bill 515, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 620, Senator Watson, criminal law wearing, carrying, or transporting a handgun, prior convictions.
Senate Bill 620 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 620 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 626, Senator Lamb, sex designation on certificate of birth, license ID cards, birth info histories, birth certificate modernization act.
Senate Bill 626 is on third reading, final passage. Recognize Senator from the capital city on the bill.
Thank you, Mr. President. Mr. President, I really want to thank the body for some of the really thoughtful amendments that were offered on this bill. Unfortunately, Mr. President, there's still a number of issues with the bill that would make it very, very hard to support. Chief among those, it still allows the parents, well, a parent, to make these designations for their children. And it allows the parent to make those designations with very little guarantees from the parent. The parent could be a non-custodial parent that's estranged from the child, that doesn't have a relationship with the child or understand their needs very well, but they still could make those designations for the parent. Additionally, I appreciate the effort to restore some language to it about a physician having treated the child or having some understanding of wanting to make those changes, but it doesn't require the physician to make any sort of attestation or certification. The language in the bill would still be the parent making those designations and the parent alone. So the parent would be making that designation based on their understanding. But the part that gives me the most pause, Mr. President, is that as amended, this bill would permanently seal the records so that those records could not be accessed. They would not even be able to be accessed by the person themselves. So if a person was a baby, was a child, and their parent made this designation and changed their sex on their birth certificate, We would now, under this bill, seal that record even from the person. So imagine that person grows up and then they want to get the original record of their birth certificate. This bill says that it is permanently sealed, and it does not give a process for how they could access the original record. The bill is self-referential, and it does say under Section 211 you would be able to, but Section 211 in the amended version of the bill, it further talks about getting a copy of the certificate, not a copy of the original record. So we would allow a person's parent, one parent, could be an estranged parent, we don't know the parent's understanding of that child, to make this decision for that child. It doesn't require that they do it in consultation with the child, no matter how old that child is. That child could be 15, 16, 17 years old, and we still would give that authority exclusively to the parent to make that designation. And then after that, one parent, and then after that, we would have these records permanently sealed. You would perhaps have to file some sort of court case where you could then maybe, at the discretion of a judge in their benevolence, if they chose to, allow the person to access their own birth record, but we would be sealing that opportunity off for them forever, Mr. President. And then not only that, should someone do that, what we have in here for an enforcement mechanism under penalty of perjury, in my opinion, Mr. President, is not a functional or operable penalty of perjury. It does not have a material statement of fact that the person would attest to. The penalty of perjury section speaks to a fraudulent intent. Intent is just one part of the law, Mr. President. They also have to have in there the actus rea. There has to be the actual thing. It has to be the statement of fact that the person is attesting to. If we don't describe exactly what the statement of fact is, Mr. President, we are leaving open the risk that people's sex will be litigated in a court of law, that the very Marylanders that we are trying to protect and trying to give an opportunity to make sure that their identity documents reflect the way that they operate in the world, we are leaving them vulnerable to claims that they would be brought into court and that their sex would be litigated in a court of law to a degree of probability to satisfy a judge, because we have not spelled out in this bill what the statement of fact is that is subject to a penalty of perjury. So with that, Mr. President, while well-intended, I would not be able to vote for this bill. Thank you.
Thank you, Senator. All right, on the bill, recognize Senator from District 9.
I just had a question for the floor leader, Mr. President.
Senator may proceed.
So I was just curious if the bill restores the current law regarding minors and birth certificate.
It does. With the amendment that we applied earlier today, the current law is restored regarding minors and birth certificates. It still requires a parent to make that request after they have worked with a provider on that for the child. So very clear to the whole body. For children, it restores the current statute. We're not here to relitigate the current statute. So that is restored. When it comes to the child, just to remind the body as well, to your question, that you only need, the current law only requires one parent. And the current law only requires one parent in a lot of different things. If a child ends up in the ICU, the decision to continue care or to resuscitate can be done by one parent. If a child is in a clinic on whether to get a vaccine for that child, that vaccine can be done by one parent. This should be no different, and this is existing statute, can be designated by one parent. The sealing part of the records here, this is applying section 211G that's already in existing statute, where there are provisions how this can be unsealed. This can be unsealed by a court order. If you get a judge to sign off on unsealing the original birth history record, that can be unsealed by a judge. That can also be unsealed in current statute by the secretary itself as well. And when they turn 18, that can be unsealed as well. In my hand here, I have a petition for change of name of an adult. This is just a template form that you can print out to be able to submit to the circuit court. And on this petition of change of name of an adult, which you can change for a whole variety of reasons, there's plenty of reasons here that you can check off on this form. For example, if you get divorced and you wanted to change your name back, you would go download this form, fill it out, and at the bottom it says, I am not requesting a name change for any illegal or fraudulent purpose, and for these reasons, I am requesting this name change, signing your name here, solemnly affirming under the penalties of perjury that the contents of this document are true and to the best of my knowledge, information, and belief. That would be the same penalty of perjury. That's the same type of document that we would apply here in this instance as well.
Mr. President.
All right, are there any senators who have not yet spoken who wish to speak? If not, recognize the senator from District 30.
Would the floor leader yield for a question?
Senator may proceed.
On the floor leader's description of the bill, the floor leader indicated that this bill, as amended, would restore to law the current code, and the current code would be restored. But under the bill section where it talks about what would be verified, it does have a section where previously in the law, it was a physician that was making a statement under penalty of perjury. And the physician was certifying that the individual had undergone surgical, hormonal, or other treatment. And then the physician could also talk about a person who was born with a status of being intersex. That language has been stripped and stricken from the bill, even as amended, correct?
That provision only currently applies to adults. It was taken off, and the current statute regarding minors was reinstated with the amendment earlier today.
And the status, the threshold as it relates to minors is that a licensed healthcare practitioner who has treated or evaluated the individual has determined the individual's sex designation should be changed. That's the only remaining language as it relates to minors, correct?
That is current statute.
So but there is some language there that's still being stripped. After that, there are parts that are being stripped out of the law that are in the current law. I don't want to say to the public that all of the entirety of the current law is being restored by this amendment. There's language in the existing law that is being stripped out and would not be restored with this amendment, correct?
The bill as amended does streamline the process for adults, but for children, for minors, it leaves it intact in as current statute states.
Well, if I look at the face of the bill and I see language that's in the current law and that language has strikeouts through it, that would indicate to me that those portions of the current law are being stripped from the bill even as amended. So there were portions that would require not only would the physician have had to say, or the licensed healthcare practitioner, that the minor was being treated, but there was some additional language there about the level of care that the minor was receiving that the healthcare practitioner was going to have to verify under the existing law. We are in fact removing that from this statute and giving the parent the ability to make those designations. Not only does the parent have the ability to make the designation, but the parent doesn't have to submit any documentation from the treating physician. The parent simply fills out the form, and it's all based on what the parent is saying that these decisions are being made. Previously, it was a physician that was making these verifications, and we were relying on our doctors, their professional judgment. They have professional licenses that are on the line if they make these statements in a way that's false or misleading. Now we are leaving this up to the parents to make these decisions, and we are also lowering the threshold by which they are making these decisions, which are clinical judgments that we are now putting in the hands of parents that they will make to the state of Maryland. Thank you, Mr. President.
All right, on the bill, are there any senators who wish to speak who have not yet spoken? Any further discussion? If not, clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will ring the bells. Madam Secretary. Clerk will take the call. With 24 votes in the affirmative, Senate Bill 626 having received a constitutional majority is declared passed. All right, clerk, read the next bill.
Senate Bill 707, Senator Reedy, Mental Health Law Definition of Danger to the Life or Safety of the Individual or Others, Reports on Emergency Evaluation Petitions, Right to Treatment.
Senate Bill 707 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 707 have received a constitutional majority, is declared passed. Is that 707? All right, let's go to 68, calendar 68. Clerk will read the first bill.
Senate Bill 715, Washington County Senators, Washington County Juveniles Truancy Reduction Pilot Program.
Senate Bill 715 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 41 votes in the affirmative, Senate Bill 715 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 742, Senator Gazzone, Maryland Medical Assistance Program and Developmental Disabilities Admin, Home, and Community-Based Service Eligibility Determinants, Maryland Protecting People with Disabilities Act.
Senate Bill 742 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 742 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 777, Senator Stalling, Labor and Employment, Workforce Development and Local Workforce Development Boards, Local Workforce Solutions Investment Act.
Senate Bill 777 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 41 votes in the affirmative, 42 votes in the affirmative, Senate Bill 777 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 831, Senator Ferguson, Labor Law, Child Labor Penalties, Private Sector Employee Labor Relations, and State Employment Labor Standards.
Senate Bill 831 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 831 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 839, Senator Reedy, Medical Assistance Programs, Drug Dispensing, Cost of Dispensing Survey.
Senate Bill 839 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 839 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 858, Senator Hedelman, Department of Budget and Management, Audit and Finance Compliance Unit Establishment.
Senate Bill 858 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 858 having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 870, Senator A. Washington, Maryland Department of Health, Adolescent Psychiatric Inpatient Beds Reports on Capacity and Outcomes.
Senate Bill 870 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 42 votes in the affirmative, Senate Bill 870 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 876, Senator Attar, Recovery Resident Certification Requirement.
Senate Bill 876 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 33 votes in the affirmative, Senate Bill 876 have received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 936, Senator West, Vehicle Laws, Bus Obstruction Monitoring System, and Bus Stop Zones.
Senate Bill 936 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 32 votes in the affirmative, Senate Bill 936 having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 983, Senator McCray, Higher Education Academic Program Approval, Objections, Process, Alteration, and Study.
Senate Bill 983 is on third reading for final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call.
Mr. President.
With 42 votes in the affirmative, the Senate Bill of 983 having received the constitutional majority is declared passed. Recognize the senator from District 5.
Mr. President, I misread something. I need to change a vote on SB 876 from red to green.
876 from red to green. Red to green. Any objections? Without objection, so ordered. Senator from 22nd.
Thank you, Mr. President. On Senate Bill 597, I would like to turn from red to green.
Red to green on 597 when we have the form?
Yes.
Okay. Any objections? Without objection, so ordered. Recognize Senator from the 32nd.
Thank you, Mr. President. On Senate Bill 340, I'd like to be recorded in the green.
340 in the green. Any objections? Without objection, so ordered. All right, Senators, we are going to take a we're going to take a 6-minute break. 6 minutes. 6 minutes. We're going to adjourn for 6 minutes. So our next legislative day will be at 9:30. Can we do a quorum call quickly, please?
Mr. President.
Has everyone recorded their presence? So the clerk will take the call. With 39 members in the chamber and a quorum being present, the Senate of Maryland remains in session, recognizing the Deputy Assistant Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand in recess until...
I think maybe we want to adjourn.
Adjourn. Thank you, Mr. President. I move the Senate of Maryland stand adjourn until 9:30 p.m. this evening.
All right, without objection, so ordered. See you in a few minutes.